come before the court is Henry Greene v. HOC Transport. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve rebuttal time, please let me know as I'll be keeping track of the time. The arguments are being recorded, so please stay behind the podium, keep your voices up. You should introduce yourselves. You should not, should it be relevant, use the names of children, minors, or victims during your arguments. You can refer to those folks with initials or terms like the child, although I don't think it's relevant in this case. The judges have read your briefs and we're ready to proceed when you are, and at this point I would ask the appellant, would you like to reserve time?
Yes, Your Honor, 5 minutes, please.
Very well, you may proceed when you are ready.
Good morning. My name is Adam Rompwine. I'm here on behalf of the appellant, in this case, HOC Transport Company. May it please the court. This case was initiated by HOC by filing a notice of appeal with the Common Pleas Court, which appealed the decision of the Ohio Industrial Commission, which found that Henry Greene, the appellee, was entitled to participate in Ohio's Workers' Compensation Fund. This is a special statutory proceeding under Revised Code 4123.512. And although the appeal is filed by HOC, which is the act that vests jurisdiction with the trial court, Mr. Greene must file the complaint and bears the burden of proof. The Ohio Supreme Court in the Bennett decision has been clear that an appeal to the Common Pleas Court under 4123 is a new trial without reference to the administrative claim file, the results of the administrative hearing, and it is not a record review or an error proceeding. It is a full de novo trial. Also, under 4123, and very critical to this appeal, the worker cannot voluntarily dismiss this without without HOC's consent.
But it doesn't speak about court orders dismissing.
It does not, no. As the plaintiff in the de novo proceeding, Mr. Greene had the burden to prove two elements: that the alleged injury arose from his employment, and that the alleged injury was the proximate cause of the condition he was seeking to have allowed in the Bureau of Workers' Comp case. As in personal injury cases, and really any case involving medical causation, you have to have expert testimony establishing proximate cause by a reasonable degree of medical certainty or probability, which has to be induced at the hearing. It cannot be inferred or brought in from the administrative claim file. In this case, there was no expert testimony. There were no experts disclosed during discovery. And under Civil Rule 26 and Civil Rule 37, if witnesses and exhibits are not identified and produced in accordance with the trial court's scheduling order, they cannot be used at trial.
Can we go back to the issue, we have this pending motion about whether this is a final appealable order. So we know it's a special proceeding.
Yes.
How does it affect a substantial right to the employer?
So in that case, that goes to the first element, I guess the first assignment of error that I raised. So the notice of appeal that HOC filed in this case vested jurisdiction with the trial court. And the dismissal cannot unvest, or it can't divest the trial court of jurisdiction. And in this case, it wasn't the complaint that was dismissed. Judge Michaels dismissed the entire case and ordered that it be marked closed.
But it could be refiled.
It cannot be refiled. The complaint could be refiled under the original notice of appeal, because that's what vests the trial court with jurisdiction. The problem with dismissing the entire case and marking it as closed is I cannot file a new notice of appeal under 4123. It has to be the original notice of appeal. So my first assignment of error is that the trial court simply cannot do what it did here and completely dismiss the case, consent or otherwise, because it cannot divest itself of jurisdiction under these circumstances. Then, as far as my second assignment of error, 4 days before trial, Henry Greene's counsel contacted me and asked if I would stipulate to the medical evidence, which was never provided during discovery. That was the first time in the case that it was apparent that there was going to be any medical evidence produced at the trial. Because of the timing of the case, I filed a motion for default judgment under Civil Rule 37. The reason I filed that is because without the expert testimony, this case was going to end in a direct verdict. The court held a hearing, continued the trial, held a hearing on that, and found that the expert testimony had not been produced during discovery and could not be used at trial, but declined to grant the default judgment. Then, about a month before the new trial date, a expert deposition was noticed by Mr. Greene's counsel, and a status conference was held with the court to discuss it because expert testimony had been prohibited in that case. Following that status conference, the judge, Judge Michaels, sua sponte, dismissed the case without the employer's consent. We believe that is also an error because the statutory requirement of the employer's consent was meant to allow employers to have their day in court, to proceed with these, with trial if they were the ones that were appealing the industrial commission's hearing. In this case, the dismissing it because of a discovery violation by the plaintiff actually punishes HOC. HOC was ready and prepared for trial, and essentially guaranteed to win on a directed verdict because of the lack of evidence in the case. And even though it was structured as a sanction against Greene, it was actually HOC was the party that was essentially punished for that. And that makes us start the case from the beginning. We have to do discovery, and essentially it allows Greene to fix the defects in his case and start it from the beginning. The third and final assignment of error in this case is that the trial court erred by not granting the summary judgment. It was conclusively established below that Greene failed to disclose the experts and would have been prohibited from using them at trial. It is a de novo proceeding, and the Greene cannot rely on any of the expert testimony below. And in the Bennett case actually parallels this case very closely. Unlike the Bennett case, HOC did not stipulate to the injury. We didn't file motions agreeing that there was an injury. We didn't file trial briefs and talk about the day of the injury and things like that. But even in that case, the Supreme Court found that without having produced it in discovery, it cannot be used. So if the trial court doesn't grant the motion for default judgment, this case has to be set for trial, and we're going to have half of the trial. The jury's going to be impaneled. The parties are going to spend time qualifying the jury, put on the plaintiff's case in chief, and then the trial court's going to have to grant a directed verdict against Mr. Greene because he cannot establish the elements required to prove his entitlement to participate in the fund. For that reason, we believe that the trial court's ruling that the evidence is inadmissible but denying the default judgment is an error because it leads to an illogical conclusion that's going to burden the court system, burden the jury, burden the parties with a trial that we know is going to end in one way. So therefore, if the panel has no questions, HOC respectfully requests that the court overrule the trial court's dismissal without prejudice, and further requests that the court order that the trial court grant a motion for default judgment in favor of HOC Transport Company.
Thank you, Attorney Runkle, and when we get to your rebuttal time, you'll have your full 5 minutes.
Thank you.
Good morning. My name is David Meyerson. I represent Henry Greene. May it please the court. The issue in this case was a technical violation of discovery order. I'd like to clarify a little bit of the facts. The experts were identified in this case. There were answers to interrogatories in which the two treating doctors who were listed as experts were identified very early in this case. The only thing that wasn't produced, it should have been produced with those answers, was a copy of the medical records or / reports that the doctors had authored and were produced administratively in this claim. And so the parties actually had those records from a long time back because while this case was pending in court, administratively, additional conditions were added to the workers' compensation claim, including a rotator cuff tear with the same treating doctors, okay, and a request for cervical strain with the same treating doctors. And so all those records were clearly in the hands of defense in this case as well. The right shoulder, rotator cuff tear was not appealed by the employer, which was granted in the claim, but the cervical strain, which was denied, was appealed to court by the plaintiff. So there's another pending administrative appeal in court as we speak. So the only violation here was the technical violation of providing those medical records / reports from the treating physicians in this case. There was no new doctors, there was no new medical, none of that. And the issue in this case from the beginning was clearly whether or not Mr. Greene was the employee of HOC. This was the subject of the motion for summary judgment. This was the subject of earlier discovery dispute. In the same answers to discovery that were provided, there was a dispute because plaintiff had not provided some tax returns and some other records that were relevant to the issue of whether he was an employee. And so when that was corrected, defense counsel notified the court, said, hey, it's all corrected, we no longer have to have a hearing on our discovery dispute, okay? After that, there was absolutely no mention of any issue with discovery or records missing or any attempt to correct anything from discovery, not until 4 days before trial with the motion for default judgment. I attempted to streamline the trial, thinking, well, now that the court granted or denied the motion for summary judgment only about 3 weeks before trial, maybe we could streamline the trial and just deal with the issues of employment, since that was the issue, and that was actually identified by defense counsel in a stipulated entry in the other appeal to court, which was trying to stay that case until we could rule on the issues in this case. But all of a sudden, when the motion for summary judgment was denied, all of a sudden it became a big deal that they didn't have these medical records reproduced for them in the court. But the magistrate had the jurisdiction over the hearing and was going to conduct the trial in this case. And so the magistrate held the hearing, and the magistrate ruled that it was a non-willful violation of a discovery issue. And also denied the motion for default judgment. That was never appealed or objected to by the defense, by HOC. They have never objected to that. But today they're objecting to it. The law clearly states that in order to preserve issues for appeal from a magistrate's decision, you must object to those issues.
Counsel, is it the same with the magistrate's order? Because since jurisdiction was given to the magistrate in this, we're operating under Rule 53, magistrate's order versus magistrate's decision.
Right, so the magistrate's order, which we objected to, okay, needed to be objected to by HOC if they didn't agree with the findings of fact or the conclusions of law or the sanction, okay, in this particular case. Yet they did not do that, okay? Plaintiff did that. We objected, and that's what prompted, the judge had to rule on that, so that's what prompted the ruling and the dismissal of the case, okay? The fact that I had notified and noticed up another a doctor's deposition after the magistrate's order, that order was not final because the judge had not accepted it yet. The judge had not ruled on that order, or whether or not that order was going to be instituted in this case, or whether the judge was going to enter a different order. Okay.
And is it your understanding or belief that the trial court did accept the magistrate's order?
The judge accepted the magistrate's findings of fact, okay, and conclusions of law. I think actually the judge says in her order, okay. The only thing she changed was the sanction, I noticed that deposition was because I needed to protect the record, you know, in case the doctor was going to be excluded. I needed to protect the record, and I wanted to proffer what he would have said. But in any event, it was a non-willful violation. The law also clearly states that granting the default judgment or dismissing a case with prejudice because of a non-willful violation is contrary to law. It has to be a willful violation, something that is egregious, willful. That is what equals the dismissal of a case. The remedy that HOC wants in this case is too harsh for the violation in this case, especially since the evidence that they are claiming that they don't have, it was in a shared BWC file, and evidence that they clearly possessed through the administrative process. And although the rule required plaintiff to give it to them again in the trial court, I'm not saying it wasn't required to do so. I'm just saying that that was not a willful violation, and therefore the remedy that is sought was inappropriate. And the judge's remedy by dismissing the case has now cost the plaintiff, because the plaintiff has to incur the filing costs from the original appeal, plus the plaintiff has to incur the filing costs and from the second appeal that the plaintiff has to refile. I don't believe the judge's order divests the actual trial court from fully handling the case. If the plaintiff doesn't refile this case timely, then the HOC could file a motion with the trial court to ask for a judgment, the default judgment that he seeks today. And so the burden is now on the plaintiff to make sure that that complaint gets refiled timely, and if the plaintiff doesn't do so, then HOC would be successful in their case. So because it was a non-willful violation, and because they never appealed or objected to the magistrate's findings and conclusions, the order of the trial judge should stand. And it was not an abuse of discretion. I mean, this is abuse of discretion review of a trial court's order. There is absolutely zero evidence of abuse of discretion from the trial court. And there is no evidence that it wasn't anything but a non-willful violation of the discovery order. So on those basis, I believe that the judge's order should stand. It was an order that was not sought by the plaintiff. Plaintiff did not ask for the dismissal, but the judge did it on her own, and is a penalty on Mr. Greene. So therefore, I believe that it should stand. Thank you very much.
Thank you very much, counsel. And you will have your full 5 minutes.
Thank you, Your Honor. With respect to appealing or objecting to the magistrate's decision, HOC did not do that. HOC had no problem with the magistrate's decision as written. We were happy to go to trial with the exclusion of the expert testimony for the reasons that I set forth in the first part of my argument. However, the judge's order did not adopt the magistrate's decision in full. It modified the order, which is what we objected to. With respect to the discovery violation, Civil Rule 26B7 requires that if you want to use expert testimony, you have to produce reports and CVs for your experts. In lieu of producing reports, you can produce the actual records. And the Bennett case is manifestly clear that this is a de novo proceeding. So the constant references in the record and an argument to all this information that was available in the administrative record has already been ruled on by the Ohio Supreme Court. The fact that it exists there is irrelevant to whether it is admissible as evidence in a de novo trial before the Common Pleas Court. And I would ask the court to consider it this way. If this was a DUI case and the prosecutor had a good field sobriety test and a breathalyzer test that the driver was clearly over the limit, and just didn't enter it into evidence, didn't put it on the exhibit list, and showed no indication prior to trial that the prosecutor was going to introduce that evidence at trial. The defense attorney would correctly and rightfully object to the introduction of that evidence, and the court should exclude it because they didn't follow the rules. The prosecutor at that point can't say, come on, you had a field sobriety test, you had the breathalyzer results, you know he was drunk, why follow the rules? We all know what happened. That's what's happening here. The rules weren't followed, and the evidence simply cannot be allowed in. With respect to the penalty on the case, the purpose of the change in 4123, which was amended in 2006, I believe, the purpose of the amendment to that was to actually prohibit these cases from being dismissed. In many of these workers' comp cases, they're filed, they're appealed up, they're 41A right before trial, and the employer has to litigate the whole case again. The statute was changed to eliminate the ability of the plaintiff to 41A a case without the employer's consent, to remove that burden from the employer, and also to give these cases the priority that they're entitled to under the statute. Under 4123, these are supposed to be priority cases, and they're supposed to be treated as such. They apparently, I was not practicing law at that time, but they weren't being treated. They were being appealed, 41A, and started again. So the point of the statute is to prevent the abuse and the delay that is associated with the constant dismissals and refilings of these cases. In the research that I did in the briefing, there is no indication that this has ever happened where a court has dismissed I guess, sua sponte granted a 41A motion to get rid of the case rather than trying the case. And with respect to the request for default judgment, that is just a logical extension of what must happen in this case. If the motion for default judgment remains denied, HOC is happy to go back to the trial court, have this case set for trial, and try the case.
Wouldn't it be summary judgment? I don't understand. Did that get denied before this discovery sanction, or
So we filed summary judgment on the employment issue. We did not file summary judgment based on the lack of the medical evidence earlier in the case. So under Rule 56, we're permitted but not required to file for summary judgment on the entire case or just certain components of the case. So that was never heard by the court, and it wasn't until much later in the case and very close to trial that I was contacted and realized that this medical evidence was going to, I guess that I was being requested to stipulate evidence that had never been introduced in the trial. So again, for those reasons, we would ask the court to overturn the trial court's dismissal and then also direct the trial court, just for purposes of the judicial economy and fairness, to enter a default judgment because of the discovery violations in the case. Thank you.
Thank you. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of that decision to you on the day that it is released, and the opinions will also be posted on the Ohio Supreme Court website. Thank you again.
Thank you.